Hello viewers, welcome to my channel. I'm Hasham Ali Khan. So this is the second video on Sale of Goods Act 1930. The last video I have explained you about the meaning of the term contract of sale and what are the essential elements of a valid sale that I have explained in the previous video. Hope you have watched that video because this is the continuation of the previous video. If you have not watched the first video, you cannot be able to understand the second. So I suggest you to go to the playlist of my channel, select the subject business law, select the video on Sale of Goods Act. First video, essentials of a valid contract of sale. Then you can come to this video. So in this video, I'm going to explain you about the differences between sales and agreement to sell. Very often in examination, a question will be asked regarding the differences between sale and agreement to sell. Because a contract of sale includes both. A contract of sale includes sale as well as agreement to sell. So a student must be able to know what are the differences between sale and agreement to sell. In examination, it will be asked. Apart from that, in this video, I'm going to explain you about the meaning of the term goods and what are the different types of goods, classification of goods. So these two questions I'm going to cover up in this video. First of all, the differences between sale and agreement to sell. What are the differences? First one, sale is an absolute sale. Sale is an absolute sale because the ownership is immediately transferred from the seller to the buyer. In this sale transaction, the ownership will be transferred from the seller to the buyer. The buyer will pay the price. Example, a person goes to a electronic shop. He wants to purchase a television. He has paid the price and he got the television. That's all. Sale transaction over. Now what do you mean by agreement to sell? It is a conditional sale. Agreement is made now, but the sale will be completed on a future date or on fulfilling some conditions. On fulfilling some conditions. That's why it is called condition sale. So first difference, sale is an absolute sale and agreement to sell is a conditional sale which depends on some condition or on a future date. Second, ownership immediately transfer. In case of sale transaction, in case of sale contract of sale, ownership is immediately transferred from the seller to the buyer. That means the contractual relationship will be discharged immediately in case of sale. Both the parties have completed their promises. The promisor as well as promisee, both have completed. So transaction is completed. Ownership is transferred from the seller to the buyer. Whereas in agreement to sell, ownership will be transferred in future or on fulfillment of some conditions. Because the transfer ownership will be transferred on a future date or on fulfilling some condition. The ownership is not transferred at the time when agreement is made. The ownership will be transferred on a future date or on fulfilling some conditions. Third one, buyer becomes owner immediately after sale. In case of sale, contract of sale, the buyer becomes the owner immediately after taking the ownership. But in seller continues to be the owner till the time when he has paid the amount. Owner, even after the agreement to sell. Even after the agreement to sell, the seller will remain the owner. The ownership will not be transferred. Only after fulfilling the conditions, only on a future date, the ownership will be transferred. Next one, it is called an executed contract. Contract of sale is an executed contract. Executed means completed. Both the parties have completed their obligations. The seller has transferred the property and the owner and the buyer has paid the price. Buyer has paid the price. That means the contract is executed. Whereas in case of agreement to sell, the contract is called executory contract. That means both the parties have still to perform their obligations. The buyer and seller have not completed their obligations. Only they have entered into an agreement. Executory contract. Now it gives right on goods to the buyer, which is called jus in rem. It gives the right to the buyer against the property. Just in rem means against the property. This jus in rem is a Latin word. The meaning of jus in rem is right against the property. That means when the buyer has paid the consideration to the seller, now buyer will have the right to get to the property. The buyer will have the right against the property. Jus in rem, right against the property. To whom this right is given? To the buyer. To the buyer in case of sale contract. In case of agreement to sell, it gives right against the seller, which is also called jus in personam. A right against person. Jus in personam. The meaning of this is right against the person, not against the goods. So, if there is a violation in case of contract of sale, then the buyer will have the right against the goods. He can demand the goods. But in case of agreement to sell, if there is a violation by the seller, buyer will not have the right against the goods. The buyer will have the right against the person, means seller. He can sue the seller. He can sue the seller for damages. Next, the goods must be existing with the seller. In case of sale agreement, in case of contract of sale, the goods should be on the hand of seller. Existing goods must be there. Existing goods must be there in case of sale contract. In case of agreement to sell, it may be existing, or it may be future goods, or it may be contingent goods. Any type of goods may come in the case of agreement to sell. Whereas in case of contract of sale, only existing goods must be there. That is the next one is, in case of breach by the seller, the buyer can claim delivery of goods. Whereas in case of breach, the buyer can claim damages. In case of breach by the seller, the buyer can claim damages but not goods. Just now I told you jus in rem, jus in personam. If there is a breach of contract by the seller, the buyer can claim the goods. The buyer can sue the seller in a court of law and demand the goods in case of contract of sale. But in case of agreement to sell, the buyer can sue the seller only for damages. Personally, he can sue for damages. He cannot demand for goods. Last one is the risk of destruction of goods after the sale, if any, falls on the buyer, being the owner. Suppose if the subject matter goods are destroyed after sale, that means this loss should be borne by the buyer, because as soon as sale is completed, the ownership in the goods is transferred from seller to buyer. Now buyer is the owner, so if the goods are destroyed, it should be the loss of the buyer, not of the seller. But in case of agreement to sell, if the goods are destroyed after agreement to sell, the loss will be of the seller, not of the buyer, because the property in the goods is not yet transferred. The owner is still the seller. So destruction of subject matter should be borne by the seller in case of agreement to sell. So these are the differences between sale and agreement to sell. In examination, theory question will be asked like, explain the differences between sale and agreement to sell. Now I am coming to the next question in this video called, what are goods and what is the classification of goods or types of goods? So in examination, this question may be asked regarding goods. The subject matter of the contract is goods. The contract of sale is made for the purpose of goods. The subject matter in between the buyer and the seller are goods. So there should be clarity regarding the meaning of the term goods. The Sale of Goods Act 1930 has given the definition, meaning of goods. If we are not sure about the meaning of the term goods, we cannot be able to know the provisions regarding the Sale of Goods Act. So goods form the subject matter of the contract of sale. So without goods, no contract of sale. So goods are defined as section 2 subsection 7 of the Sale of Goods Act 1930 has given the definition of the term goods. According to this definition, goods, every kind of movable property. First you have to remember, goods means movable property. Immovable property are not goods according to Sale of Goods Act. So when a person sells immovable property like house property, that will not come under the category of sale of goods. That will be taken under by some other law is there for transfer of immovable property. Here, goods means any type of goods which are movable. Every kind of movable property other than actionable claim and money. Two things you have to exclude. Actionable claim, that means amount due from other person, that is actionable claim, or money, that is not good, and includes shares and stocks, and growing crops, grass, and other things attached to the land, attached or forming part of the land. Any other thing which is attached or forming part of the land that can be severed, that can be detached at the time of sale or at the time of agreement to sell, before sale or into the contract of sale. So this is the complete definition given by section 2 subsection 7 of the Sale of Goods Act. What is that? A sale, every kind of movable property other than actionable claim and money, and includes shares and stocks and growing crops, grass, and any other thing which is attached to or forming part of the land that can be severed at the time of sale in the contract of sale. This is the definition of the term goods. Now, classification of goods, types of goods. Broadly, goods can be classified into three categories: existing goods, future goods, and contingent goods. These are the three. Existing goods. Under existing goods, again we have specific goods, ascertained goods, unascertained goods. So first of all, we'll discuss about existing goods. Goods owned and possessed by the seller. Goods owned and possessed by the seller at the time of entering into contract. At the time of entering into contract, the goods are owned and possessed by the seller are called existing goods. Now, the existing goods can be classified as specific goods, ascertained goods, unascertained. First of all, specific goods. The goods identified and agreed upon at the time of contract of sale are called specific goods. When the buyer and seller has identified and agreed at the time of contract of sale are called specific goods. Example, Mr. A goes to an electronic shop. He has decided and identified that this television I want to purchase. This television I want to purchase. That means it's a specific goods. Because the buyer and seller has identified, defined that this is the item I want to purchase. It's a specific goods. Next is ascertained goods. Ascertained goods means the goods are not identified, but it will be identified after making the contract. After making the contract. The goods which are ascertained or identified only after formation of contract. First formation of contract. Contract is completed. Mr. A goes to the shop. I want to buy a television. The television cost is so and so. Okay, decided. I want to purchase it. Agreement is over. After that, they have identified that this television I want to purchase. So, from the mass of goods, the item is selected. So, they are called ascertained goods. Unascertained goods. That means the goods which are not identified and ascertained at the time of sale are called unascertained goods. They have not at all ascertained. An agreement is made, but ascertainment will be done after that. So, they are also called generic goods. Generic goods, that means goods are completely lying in the go down, lying in the shop. Just we have to identify after completing the contract. So first the buyer has paid the price, enter into contract, and then identify. Then goes the buyer and seller goes to the mass of the goods, and there they will identify which goods the buyer wants to purchase. They are not definite or specific. They are goods defined by description only. At the time of making the contract, only description has been given by the buyer to the seller regarding the goods. So existing goods can be specific goods, ascertained goods, or unascertained goods. Now future goods. Second category of goods are future goods. Now future goods are goods which will be manufactured or which will be produced by the seller after making the contract of sale. So first of all, contract of sale is completed between the buyer and the seller, and then after contract of sale, that means after making the agreement, the seller will produce the goods, will make the goods and will supply the goods. So in other words, it is not a sale transaction, it's an agreement to sell, because goods are not specific existing at the time of sale. At the time of sale, goods are not existing. The goods will be produced in future. The goods will be produced, manufactured in future. So first of all, a person will come. Example, if I want to make a sofa set for my drawing room, I goes to a furniture shop, a carpenter, a furniture maker is there. I asked him to make a sofa set according to my description, and you make it sofa set and supply to me. So here the contract is made right now, but the goods will be produced, manufactured on a future date. These are called future goods. There cannot be a sale of future goods. That's why we should not sell. It is an agreement to sell. It is an agreement. So a contract of sale for future goods is called an agreement to sell, not an actual sale. Last one is contingent sale. The sale which is dependent on some contingency happening or not happening. That means the sale transaction will be completed only on the event. The event is uncertain, contingent. It may happen or it may not happen. Those goods which are dependent on some condition are called contingent goods. So goods, the acquisition of which by the seller depends on uncertain contingency which may or may not happen are called contingent goods. Simple example, I have imported some goods from a foreign country. The goods are still on the way. So I entered into a contract with a buyer. I am the owner of the goods. The goods are not on my hand right now. The goods are on the way, in transit. And before reaching the goods to the port of our country, I entered into a contract with Mr. X that after receiving the goods, I will sell the goods to you. That means the contract which is made now is a contingent. The goods are contingent goods because we are not sure whether goods will be received or not. So if the goods are received, then only the contract of sale will be completed. It will become enforceable. If the goods are not received, the contract is not enforceable. So a contract for sale of contingent goods is enforceable only when the event of happening of which the performance of the contract depends has happened. The performance of the contract depends on the happening of the event. What is that event? The goods must reach the port. The goods must be in the possession of the seller. Then only it will become enforceable. For example, X agrees to sell Y a ring. There's an agreement. X agrees to sell a ring to Y upon the condition. What is that condition? Provided he is able to purchase it from the present owner. Actually, ring is not in the possession of X. Ring is going to be purchased by X from the present owner. So if the present owner sells the ring to X, then X can be able to sell the ring to Y. That means the goods are contingent goods. The ring is a contingent good because if the present owner sells the ring to X, then only X can be able to sell the ring to Y. So this type of goods are called contingent goods. Contingent goods. Another example, a farmer is there. A farmer enters into an agreement with the commission agent that I will sell my crop provided there is no cyclone. If there is no cyclone, destruction of the crops, I will sell the crops to you. That means the agreement is dependent on contingent goods. That's all. So in this video, I have explained you two questions. The first question, differences between sale and agreement to sell. And second question regarding the goods. What do you mean by goods according to Sale of Goods Act? And what are the different types of goods, that is existing goods, future goods and contingent goods. That's all. So this is the end of this video. So if you are satisfied, give a like to the video. Share my channel in your group, in your friend circle so that more students can watch the video and enhance their knowledge. Give your comments, and lastly, don't forget to subscribe my channel if you have not yet subscribed. And inshallah, the discussion will be continued on sale of goods in the next video.